Good morning, everyone. Welcome. I hope this webinar finds you and your loved ones all safe and healthy. My name is Tim Walsh. I am one of the partners in the restructuring group at McDermott, Will & Emery. With me is Chuck Gibbs, also from the restructuring group. We have two great speakers from McDermott as well, from the oil and gas group, Ed Zelke and Tim Alvino. And then from Ancora, we are lucky to have Scott Pincinel and Jay Squires with us. And we have Russell Mason from Houlihan Lokey. Those are all of our speakers for today. Today we're going to talk about many things in the oil and gas arena. We're going to talk about how to manage financial distress issues in the oil and gas space. We're going to examine the current state of play under certain contracts like gas gathering agreements and PPAs. We'll also talk about COVID-related market disruption and how we see the market reacting. We'll take a look at some of the strategies for addressing some operational concerns. And then we'll briefly look at a few M&A issues that are popping up pretty frequently in the oil and gas space. We do have the ability to take questions. You can use the chat feature on the Zoom, and we will get to those questions as soon as we can, assuming that we have enough time to get through them. And if we don't, we will follow up with emails to you, and we will get all those questions answered. So welcome, everybody. We'll jump right in and talk a little bit about how to manage insolvency and financial distress issues. And a trend that we're seeing in the oil and gas space is multiple filings. We have debtors going in not just once, not just twice, but in some cases 3 times. Really a phenomenon to have a company go in to a bankruptcy proceeding 3 times and survive. And Chuck, I was wondering what you thought might be the cause of that.
Thanks, Tim. I think we should probably rename the ones who file 3 times instead of Chapter 33s. We just should call those trifectas. We have seen a lot of Chapter 22s, relatively speaking, over the years. Over the last 25 years, actually, believe it or not, over 15% of publicly traded companies that were acquired through or that emerged from Chapter 11 had to refile. And the recidivism rate for companies that emerged as an independent entity during that same time period was really over 20%. And so you have to ask yourself why that larger percentage of Chapter 11s that were supposed to fix the problem didn't. I think there are several factors that I've seen over the years, and I'm sure others on the panel have additional perspectives. But from my standpoint, generally, the overarching reason is that the company that exits the first Chapter 11 does so with too much debt still on their capital stack, and that they didn't delever sufficiently the first time. A second reason I see a lot is really based on faulty feasibility studies. In order to exit Chapter 11, you have to convince the court that the company seeking to confirm a plan is not going to need further financial reorganization. And to do that, they put forth a feasibility analysis that shows that they're going to have sufficient cash flow to pay off the debts that they continue to owe pursuant to the confirmed plan. And oftentimes we've seen that those feasibility analyses are made on pricing assumptions regarding future commodity prices in the energy space that have proven to be too aggressive or too optimistic. It's especially the case if the debt owed by the company in the first Chapter 11 was owed to traditional banks or CLOs. Both of those have an aversion to taking equity, and so they frequently required that the emerging company keep debt on the books, and that has, I think, exacerbated the problem of a potential second filing. Even ones that reorganized post the late 2014 collapse in the pricing and came out with a properly deleveraged balance sheet. I think that the management of those reorganized companies oftentimes repeated the same mistakes that management pre-bankruptcy in the first case had made. And they put new debt on the company after they emerged to finance acquisitions that turned out not to pan out the way they had hoped as commodity prices fell again based on oversupply. Maybe a final factor that I've seen, at least, that have caused the 22s have been mismanagement of hedging practices, operational issues in the oil and gas space where there's turned out to be lower than expected price production. Let me spend a minute just talking about the legal basis for Chapter 22. The practical effect of those, because I think the legal basis for 22 is actually suspect if properly challenged. The practical effect of the second Chapter 11 is really an amendment of the prior confirmed plan, and that's prohibited under Section 1127 of the Bankruptcy Code to amend it post consummation of the plan. And it also oftentimes further modifies the rights between debtors and creditors that are limited by the restrictions in Section 1141. There's been several cases that have taken a look at whether or not you can challenge the 22. It's usually done on the basis of a good faith framework and a good faith analysis. A 4 or 5 year old case out of the Southern District of Texas where most of the oil and gas cases are getting filed. It's called JCP Properties, really laid out the issue well. The judge there said when the subsequent case is so related in time or substance so as to offend the traditional notions of res judicata, then there's a good possibility that the second Chapter 11 could be dismissed. The court developed a 5-part test, and the two probably most critical factors are the length of time between the two cases and the foreseeability and sustainability, or substantiality rather, of the events that caused the second filing. So if you've got a situation where the company goes in a second time relatively closely after the first one exited, and it's based upon misguessing on future pricing for the products being produced by oil and gas company. I think it's not too hard to argue that the fluctuations in commodity prices were foreseeable, and as a consequence, you, I think, can mount a successful challenge if you choose to try to get the second Chapter 11 dismissed. There's been a number of recent Chapter 22s in the oil and gas space, Ultra, Vanguard, Hilltop. And then there's been a bunch in the non-energy space. You've got Charming Charlie's and Gymboree, and Payless, the beloved Chuck E. Cheese filed 3 or 4 nights ago. And the judge there called it an American institution. For those of you who have labored through children's birthday parties there, American institution isn't really the name that comes to mind with regard to Chuck E. Cheese. But nevertheless, there are a lot of 22s, a couple of 33s, or the trifectas. And I think we'll see some more in the future. I'd be interested in perspectives maybe from Jay or anyone else on why you're seeing 22s.
Well, let me ask that question, Jay. From a financial advisory perspective, I suspect, from what you just heard from Chuck, from the legal perspective, the companies get it, the companies understand it. They may not understand the risk, but from a financial advisory perspective, what are you seeing? What are you telling the companies that are considering doing a second filing, or actually a third filing, about their possibility of getting out in a reorganized fashion?
Thanks, Tim. Yeah, I think you have to, part of all this is consideration of who's holding the debt. The number of, as Chuck referenced, the banks, the CLOs, to a lesser extent, insurance companies and mutual funds all have very limited baskets for equity. And stuck with that restraint, it's very hard for these companies to come out as a full equity entity, at least until that debt gets handed over to people who want to take over the management, or the banks themselves set up teams that can run oil and gas companies. And, you know, it's a little bit of the old, like they say here in Texas, dance with who brung you. A lot of these management teams just resaddle up and go again because they don't, the debt holders, the Fulcrum Securities don't have an alternative management team to take over. And they just want to move through. Obviously, the costs of bankruptcy are very high, as we all on this panel benefit from, but they want to get out quickly. And so sometimes the easiest way is to just resaddle the horse and put the team jockey back on and go forward. But it's obviously, we've all been through the negotiations, and you have to consider the debt holders' limitations on what their baskets are. And that's going to drive, you know, what maybe if every one of these companies in 2014, 2015 had come out debt-free, they wouldn't be looking at this again, but that's not practical in today's, you know, financial world.
It's an interesting perspective. And Russell, from a banker's point of view, these 22s, these 33s, can they be successful?
Yeah, you know, I think once you get to a point where you're filing again, you know, we expect to see more asset sales. You know, generally when you exited and, you know, you underwrote a case of a PDP blowdown, you know, the economics made sense. However, you know, E&P companies aren't run to, you know, to just harvest cash flows. And so realistically, as they exit and have, you know, some amount of leverage on them, they just don't live within leverage-free cash flow. So you continue to borrow to put the drill bit to work, and ultimately you find yourself back with, you know, higher RBL borrowings, you know, more funded debt, as Chuck mentioned, through acquisitions. And so when you get to that next point in time, you know, generally we see these assets ultimately, you know, being sold. You know, it's kind of early innings of this current cycle, but that's what we expect. And, you know, I think companies that are going through their second, third bankruptcy, these were, you know, second, third tier assets with higher operating costs, and in a volatile commodity price environment. You know, there just isn't, you know, the flexibility they need and or the profitability to continue to operate. So hard to see anything other, you know, continued standalone restructurings on these assets, and ultimately we think that that they'll be sold.
Thank you for that, Russell. We, you know, a couple of months ago saw doomsday pricing in this industry, and we've seen a relatively recent recovery. How do you think that will impact the strategies for oil and gas companies going forward, making a consideration as to whether they should file for the first time, for a second time, or a third time?
Yeah, so you know, while certainly the commodity price deck has improved, you know, we've kind of entered a purgatory phase where the bid ask between buyers and sellers still has a pretty wide gulf. You know, I think basin consolidation was the key theme, you know, at least over the last several months. And we'll see if ultimately, you know, that plan can be effectuated to take cost out. But, you know, realistically, you know, sub $40 in and around $40 oil doesn't work for most operators. So while I think it's a pause today, there just isn't, you know, the requisite liquidity in the market to keep these businesses afloat. And, you know, we've kind of just gone through the spring redetermination period with RBL lenders. And, you know, as they think about their risk profile and continuing to fund, you know, operations that don't generate free cash flow, we expect, you know, bankruptcies to pick up. And this has just happened over the last several months. So you finish redeterminations, companies just don't file all at once. There's a lot of planning that goes into these things. So, you know, our expectation is that while I think there's, you know, been 18 filings through May in upstream and several more in the month of June, we think that trend is going to continue.
And Scott, from a financial advisory perspective, is there more optimism now when you're doing your projections for financially distressed oil and gas companies simply because the price is higher, or is there a realism that, hey, look, it can go right back down again? What are you seeing on that front?
Well, I think Russell made the perfect comment. I think companies look at it from a lease level up, right? They look at it profitable at the lease level, the field level, and then as the revenue run rate. A lot of this depends on their hedging program, but ultimately, companies are it's going to be dependent where located, what is, what their lifting costs are, what their estimation is, and what their hedging portfolio looks like to get shuffled into their cash flow analysis as to what their runway looks like from a perspective. Again, as Russell points out, from the capital, pretty thin right now, so I don't see lifelines. I think he's in survival in terms of trying to conserve as much cash where they can to create as much runway, either with the hope of optimism price perspective or to manage a structured filing. To come out of optimism, I think volatility game, some measured optimism baked now, although given the COVID situation over the past week and a half, I think that optimism is trending downward a little bit.
Yeah, thank you for that. Let's get a little more granular into some of the issues that potential debtors are facing, and one of them is the examination of existing contracts. And specifically with respect to gas gathering agreements and PPAs in distressed circumstances. And I know you've been dealing with this issue a lot recently. Can you give our audience an overview of what's happening with them?
Sure. Thank you, Tim. And welcome to the audience. And as you mentioned, oil and gas prices have rebounded a bit. Natural gas prices have not. Natural gas prices are now down south of $1.50 per million BTU, and they're in a great deal of hurt, and a lot of reasons to look at the contracts that may be impacting your sorry about that, impacting your situation. The first thing you want to review your contracts for a few reasons. One is to find out whether you need to make adjustments to contracts, and with natural gas prices as low as they are, speaking to the counterparties to those contracts to see whether or not some adjustments can be made to keep you out of bankruptcy is usually a good first step. Second, you want to find out what rights you have within those contracts. Do you have shut-in clauses with some royalty payments? Do you have force majeure provisions? Do you have cessation clauses or other provisions? And third, you want to take a look at them to figure out what would happen if a filing occurred, whether you were on the side of the producer or a financier or a third party. Gas gathering agreements have a particular importance here. They have always been designed to be contracts that run with the land, so that if there's ever a transfer of the field, the gas gathering agreement goes with it. You put a lot of money into pipelines and compressors and the like to move the gas to its point of delivery. So you want to keep those agreements in place. You also have a situation though with gas gathering agreements where there's a split of authority among the bankruptcy courts as to what would happen if the producer were to go into bankruptcy. Again, you want to call these covenants running with the land. You want them to be a contract that's not rejectable in bankruptcy. But the New York Bankruptcy Court about 3 years ago, came out with a Sabine case. And the Sabine case said that, in fact, the gas gathering agreements are executory contracts, or in that case it was, and could be rejected by the court in bankruptcy because it failed to meet the three-part test for a contract that runs with the land or covenant running with the land. And that is, does it touch and concern the land? Does it have privity of estate? And did the parties intend it to be a covenant that runs? And what the New York court found in Sabine primarily was that the separation of the gas from the ground and putting it into the pipelines changed it from a mineral interest or real estate interest to personal property. And as personal property, it was not subject to a covenant running with the land, and therefore the contract was a regular contract and could be rejected. It also found that there wasn't a privity of estate. And this really kind of rocked the world for those of us in this business, because what we thought was pretty solid ground was now a quicksandish. Fortunately or unfortunately, I guess depending on where you sit, two subsequent cases they haven't rejected the Sabine reasoning, but they certainly have distinguished it to the point of maybe rejecting it. A case out of a Colorado court applying Utah law last August called Monarch Midstream versus Badlands Production. And the second case just this past December out of the Southern District of Texas, the Houston area, applying Oklahoma law called Alta Mesa Holdings versus Kingfisher Midstream. Both found that, in fact, the gas gathering agreements would continue to be covenants running with the land if they applied to the gas reserves in place. So it's really important to look at your gas gathering agreements and determine whether or not they apply only to the severed gas or whether they apply to the entirety of the reserves. I looked at lots of gas gathering agreements, and they are kind of all over the place in this area. The other thing I guess we learned here, in addition to kind of that particular provision of your gas gathering agreement, is if you are thinking about filing for bankruptcy and you either want to keep your gas gathering agreement in place or not, the selection of the court right now may be important. Obviously, Southern District of New York continues to think the gas gathering agreements may be rejectable, where the bankruptcy court outside of Houston and that in Colorado feel the other way. One other thing here, if you're talking with the gas gathering agreements today, you are in many cases talking about whether or not it is time to provide some relief to the producer. We are having a lot of conversations about with gas at $1.50 a million BTU, and if the gas gathering fee, either based upon volume for dry gas or maybe based upon a BTU rating for wet gas, is, say, 45 cents of that $1.50. You may need to talk about whether or not you need to adjust that contract. If you are adjusting the contract, it might be an opportunity to make some adjustments in the language of what the contract applies to.
I got a couple of questions from our audience asking about what happens to royalty interest holder contracts, and are you seeing them renegotiated?
If we're talking about the renegotiation within the gas gathering agreements, I wouldn't call it a royalty, it's more of a fee, and I think those are being renegotiated. In terms of royalty interest with respect to lessees, we are seeing some discussion. If you're looking at a lease right now, an oil and gas lease, you have to think about whether or not it's in its initial term or its renewal term. If it's in its renewal term, there probably is a provision that says it's terminable if you fail to produce in paying quantities. I think that you'll have some provisions in those leases often for shut-in royalties or force majeure and the like, and so you may have an overall discussion with regard to your leases. And one of those discussions might be, given the price of gas versus going to a shut-in situation or exercising one of these cessation clauses, is to whether or not a lower royalty would be appropriate. And we are seeing some of those discussions occurring, not as much as you would think. I think folks can't believe that natural gas is going to stay below $1.50 forever, but you never know. So that's kind of where we are with the lease situation.
Hey, Tim, if you've got an extra minute, I've got maybe a postscript on the gas gathering discussion that Ed gave us. And those contracts really became they're a creature of the spinoff of midstream MLPs. For a long time, the E&P companies owned their own pipeline systems and gathering systems. And when MLPs became popular, they spun those assets off into midstream MLPs, and the market value for those was entirely derived by the market's perception that those long-term cash flows were inviolate. And in the Sabine case that Ed referred to, during the 48 minutes that Judge Chapman read her ruling into the record, deciding that those agreements were rejectable because they dealt with personal property interest under her interpretation of Texas law, the market cap of publicly traded midstream MLPs dropped $4.1 billion in 48 minutes. The reality, if the midstream contracts are for the gathering and transmission of gas, is you're frequently finding just a case of let's make a deal, because the pipeline companies need to have their pipes full, and the operator that's extracting the gas really oftentimes doesn't have a workaround. And so what you're finding in almost every case is the parties are sitting down and reaching accommodations that keep from having the court force the issue. We had that in Quicksilver, where we represented the debtor. We were selling the assets, and the buyer, and we had argued and fully briefed the issue of the rejectability of our midstream contracts. And we asked the court, who was ready to rule, it was a couple weeks after Sabine, to just sit on her ruling while the parties talked. And she kept saying, I'm going to rule tomorrow. And we kept asking the court to hold off, don't rule and change the negotiating dynamics. And the buyer and the midstream pipeline companies cut a deal. And that's frequently how these are getting resolved, because neither party can afford to go without the ability to get their product to market and fill their pipelines.
Appreciate that, Chuck. Those are good points. Let's focus now on the impact that we've seen, in particular because of COVID-19. And Scott, what have you seen? And you could talk about downstream, midstream, or upstream segments, but what have you seen as a direct result of COVID-19 on this industry?
Well, the primary externality is both as a result of the drop in demand due to COVID, as well as some of the geo events past, call it 120 days, may have settled out to some extent. The commodity price regime is forcing exploration companies to control CapEx spending. We've obviously seen that reflected in rig rates. That's operating expenses, as well as the SG&A burden that company, and all that's trickled down into a hard look at the cost. They make a primary adjustment they've made is reduction in capital spending and wells being drilled, which will have some future effect on the forward supply curve. But most importantly, what it's having now is an immediate effect on oil field those activities, and as more companies maximizing their operating margin through reduction, conserving cash, again, to preserve a runway as they manage through this lower commodity price environment. Also with the specter of probably hedges running off over a period of time as well through the end of the year. really an introspective, from an upstream perspective, a real introspective look across the entire cost structure and spending activities of that company.
We're having a little problem with some of your audio there, Scott, but we're gonna work on that and try to come back to you with another question or two. Russell, how about you? What have you seen from a banking perspective? What has happened to these companies as a result of COVID-19?
Yeah, I mean, look, I think first off, CapEx budgets have been slashed over 50%. I think drilling and completion, which was in and around 120 billion in the U.S., lower 48 in 2019, is expected to be cut, more than half this year. And so ultimately, you're going to see production declines. I think through late March into April, there was a massive amount of shut-ins that have come back online as commodity prices have improved. But we've gone from a supply side issue, certainly set off by the Russia-Saudi Arabia price war, into a demand issue, and so we're well above from a storage perspective of both feedstock crudes, above our 5-year average, as well in refined product. From a refinery perspective, our clients are seeing just depressed crack spreads, running at lower utilization, simply because you're out of storage, and that's a big issue that we see, and we'll continue to work through it. On the upstream side, as we do see production declines, unfortunately, I mean, it's a global commodity, and these barrels can be replaced, and they're being replaced as Libya comes back online, South America on some larger kind of CapEx projects that are coming online. And so these are replaceable barrels. And midstream, again, I think we've kind of touched on with the contracts, but I think coming from 2015 to today, MVCs are down for GMP systems. Long haul pipe is still anchored by MVCs, so it'll be interesting to see what happens with the Rex Ultra case, which is back in, where Judge Isker has asked for FERC's participation in those discussions, and how we think about long haul pipeline contracts through this next phase of bankruptcies. But realistically, CapEx is way down. Rigs were 265 as of last week in the lower 48, compared to 960 at this time last year. And on the completion side, frac spreads util is up slightly from 45 days ago, from a trough of 45 to roughly 70, but that's on a supply of 500. So a lot of it's wait and see, but everyone's being notably impacted.
Thank you for that. Let's focus a little bit, or at least take a guess at what we think might be some macro trends that are starting to develop. Tim Alvino, do you have a view on the demand curve buildup and how that happens, and if it does happen, and over time, and what happens to others in this industry?
Yeah, Tim, I think that Russell was just alluding to this. It's a combination on the demand curve and the supply curve. I think you have to look at factors both COVID-19 related and then non-COVID-19 related. On the demand side, it's principally driven by COVID-19. You look at things globally by region. You think about the US, North America, you think about Europe, Asia, South America. All those regions, I think, will experience different rates of changes in the demand destruction that we've seen over the last few months. I note that Opus, which is an arm of IHS Markit, came out yesterday and reported that our travel personal travel in the U.S. is back to levels of pre-COVID-19, so February of this year. But on a seasonal adjusted basis, we're still 20% below where we were last year. And so you think about that demand coming back, you think about the potential impact of pulling back, several states pulling back or putting the brakes on their phased return to the new normal. What's the impact going to be on that? So I think on the demand side, it's a real question mark, a real wild card in terms of COVID-19 and what's going to happen. And I think you'll see similar experiences in a lot of regions, except Asia may take a slightly different path. On the supply side, I think Russell was just alluding to a number of factors that are impacting that aspect in terms of oversupply that existed before COVID-19, the Russia-Saudi price wars for market share. I don't think that side of the equation is going to change as things on the demand side pick up. I think that you're going to continue to see leakage into the crude supply chain, even though there have been recent cuts. I don't think that they're going to hold. There might be a higher price point, but for U.S. producers, it's going to be continued pressure, in my view, through 2021. Of course, the wild cards, geopolitical issues, particularly in the Middle East, potential Russia-China alliance of some sort, and then ultimately the U.S. elections, frankly, and what the impact could be in terms of U.S. production based on regulatory regime changes if there's an administration change there.
Great insight. Thanks so much, Tim. Chuck, what are you seeing, if anything, developing with respect to lenders trying to come up with strategies to take over assets?
For a long time, a tactic of a lawyer representing a company that's in distress would be to threaten to give the keys to the lender, knowing that that was the last thing in the world they wanted, and it might actually bring them back to some more reasonable negotiating position because they're ill-equipped to step in and operate a difficult business. Oddly enough, we're seeing that threat may not be as effective. We've seen in recent months, last 2 or 3, several situations where the lenders have acted preemptively, where they have rights under their credit documents based upon a pledge of the equity of the operating company by the parent company with powers of attorney and certificated shares to the documents give them the authority to act without notice and take control of the equity and devote the equity. I'm involved in a case in Delaware right now where in that situation it was a mezz lender who did just that, and they without notice immediately upon default took control of the shares and voted out the board and voted their own board candidates in, and the ousted board nevertheless met the next day and immediately authorized the filing of a Chapter 11. And the first 45 days of the case were completely absorbed with a battle over the effectiveness of that pre-bankruptcy takeover of the equity, and therefore the legitimacy of the Chapter 11 proceeding. The Delaware court ruled under Delaware law, which was the operative choice of law there, that the actions of the lender had not, in essence, dotted the I's and crossed their T's as required under Delaware law to effectively take control of the shares, and ruled against the lender and left the debtor in possession with the authority to continue its business. I think it's a harbinger of what we're going to see in a number of situations where there's going to be a lot less aversion to taking control. And even if they give it back, it sure does change the leverage dynamic at the negotiating table if they've at least got a plausible argument that the efforts of the debtor to preserve itself and reorganize can be stymied by a pre-filing takeover of equity. So that's one that, and I'm dealing with one right now where we're trying to get to an extension of forbearance, and we've got to be, obviously dual tracking a plan B to get in a minute before the forbearance expires, because a minute after it does, we could find ourselves in a situation where the lender is in control of my client. So I think that's one that we're seeing, and one we will see more and more.
Thank you. Appreciate that. And Jay, how about from an impairment perspective to the senior lenders? Any trends developing there, or any trends developing with respect to resetting borrowing bases?
Yeah, Tim, thank you. I think over the last couple of months, you've seen a situation where largely banks have cut availability, but they haven't cut the lenders off at the knee. In other words, they haven't reduced availability below what they've borrowed under the facility. And I think this morning Forbes Energy released a 10Q where their banks reduced their availability to 9 million, and that 9 million is only available for LCs. But they're not in default, and they're not required to pay it back, but they literally have no ability to draw other than an LC. And I think you're going to continue to see that going forward, at least right now, until you get more lenders sort of set up like Chuck's mezz lenders. They're not going to throw them in bankruptcy. They're just going to try and cap their exposure to the existing companies. As you get down the road, if more of these lenders create these management teams, decide that there's an equity story there at the right price, or they come in and buy portfolios of bank loans or others in situations, you may actually see borrowing bases that cut people off at their knees and require them to start paying down. At that case, I think we all get very busy in bankruptcies.
Appreciate that, Jay. I want to shift a little bit to looking at how companies really would have to address their operational concerns. And Scott, you've advised many distressed companies in this industry, and I'm curious as to what your view is. Like, what are some of the strategies that really should be employed at this stage to help the companies move from point A to point B?
Sure, Tim. And can you hear me okay now?
I can.
Great. Well, one prices were at least $2 a barrel was producer production. The first step, and effective on offshore, given the base level of operations that are required offshore, but producers onshore, many of them shut production in to reduce their LOE as low as possible. We're beginning that production being status as prices have crept up over the month. Beyond that, though, I think there's going to be a permanent focus on reducing lease operating expenses at the field level. Anything that's controllable, deferring maintenance, putting pricing pressure on the oil field service. And we obviously haven't talked too much about oil field service companies, but we're seeing a file and as pass on their pricing power to the service companies. And so deferred maintenance, obviously, as Russell mentioned, a lack of a drastic reduction in capital spending for new wells. I think we'll see the real but uncompleted wells come on first as producers gain more confidence. And then as you sort of move above the lease level, companies are obviously very focused on their SG&A burn. You're seeing, especially in with the majors, large announced employee reduction in forces. You're seeing wage deflation. In other words, companies lowering salaries, eliminating bonuses for senior employees, or frankly for pretty far down the ranks. as they try to control costs wherever they can. And then I think first, and then from the office of the CFO, engaging in a constructive dialogue with their lenders for interest payment relief, anything to preserve liquidity, to again extend that runway from a cash perspective to the point where either commodity prices rebound or they're able to be more holistic in court or out of court restructuring. We are seeing some things, especially on the private side, private equity owned companies, small closely held debt being restructured out of court. But I think a lot of these companies, especially the 22s and the trifectas, as Chuck mentioned, with complex balance sheet, publicly traded debt instruments, are going to have to go through a process again.
Well, there's definitely a lot there, a lot to be looked at, and we appreciate your insight on that. I know you've been through it a lot. Let's talk quickly about some M&A topics. And Tim Albino, I know you've got a lot of experience here. Is there anything unique about what's happening right now in the distressed oil and gas space on the M&A side?
Yeah, on the M&A front, Tim, one of the things that I've seen or wondered was whether rep and warranty insurance, which has increasingly been used in a number of transactions, would be available. And as I've looked at the deals I've been involved in, I kind of divide them into two categories: those that started pre-COVID-19 and are closing during COVID-19, and those that started post-COVID-19 and are either closing now or are continuing through the underwriting process. And one thing that surprised me was that rep and warranty insurance has continued to be available on those post-COVID-19 deals or even pre-COVID-19 deals where the underwriting wasn't completed when it started. There are obviously, in addition to the standard exceptions that you would expect to see, overriding exceptions referencing COVID-19 or COVID-19 type. Some reference SARS, some reference mutations of COVID-19 in the underwriting exceptions. But the terms and conditions with that exception, that overlay, have generally stayed pat. One thing that will be interesting to see is, as you look out 2 years from now, 3 years from now, the claims experience and how the COVID-19 exception is applied to what we would in the traditional M&A space consider to have been a covered loss. So that's one really interesting factor that I was surprised to see, both the availability and that the terms and conditions haven't significantly changed other than COVID-specific references.
And Tim, while we have you, is there anything that our audience should be thinking about that would help facilitate due diligence on a transaction, with the backdrop of a potential second wave of COVID-19? Is there anything that they should be focused on?
Well, obviously, both in terms of if you're going to go through an auction process for all or significant part of your assets, one of the things that everyone looks at these days is the quality of the due diligence available. Pre-COVID-19, it was a little bit less of an issue because you could assume the standard traditional ramping up of a data room with specific contracts. You could assume on-site visits, qualitative analysis by outside independent consultants, by third-party bidders, et cetera, at a certain stage. That assumption has fallen away a little bit. Now that things are easing up, maybe it's getting a little better. But on the front end of COVID-19, there was a lot of issue around logistical assessment of operating assets. And frankly, it was, especially in international cross-border deals, very difficult to get qualitative independent third-party assessments. So if you're thinking about a possible second wave and you're a potential seller, one thing I think you can do is try to prepare the qualitative assessments that your buyers, your potential bidders are going to want to see with independent consultants. not necessarily traditionally associated with your company. So that there'll be something in the data room in addition to the contracts and related third-party arrangements that you're typically going to want to see in there.
Thanks, Tim. We did get a question from the audience, and I think this goes to you, Russell, as to whether or not we're seeing any consolidation on the M&A front, whether it be forced consolidation or voluntary consolidation. I'd love to know what you're seeing in that arena.
Yeah. So look, it's the easiest way to create value is to take out, G&A cost, especially kind of C-suite level executives. But I think as prices rebounded, we do find ourselves in this precarious situation where there's just too wide of a gulf between buyers and sellers. So capital providers looking to buy assets, PV 20, PV 25, PV 30, and not pay for any undeveloped or PUDs. I think so basically we just haven't seen a lot of those transactions occur to date. We certainly think that they're coming. But unfortunately in that environment, everyone cannot be a consolidator. So, there needs to be, it needs to be forced potentially by, either bondholders and or lenders. But we haven't seen a ton to date. There certainly have been some smaller transactions, but real basin consolidation has not happened yet. And I think a lot of that is due to the recent rebound in prices. But I think as the next several months continue to play out, it does seem that will be a focus of capital providers, just because it's the fastest way to create value.
Thanks for that, Russell. Another question from the audience. Given the bankruptcies that have occurred in ongoing companies such as Chesapeake, do we think there's going to be an increase in gas prices given the potential consolidation or slowdown of production? And I'm going to ask that to everybody. So, Russell, why don't you start us off with your 1-minute assessment of that?
So an increase in, I think that the general view is as the drill bit and CapEx dollars aren't spent, your associated gas ultimately will decrease. But I think on the supply side, it's going to take a while for that to actually occur. But yeah, I think certainly you expect overall gas production levels to decrease, less through consolidation and more through just associated gas falling off. But however, gas focused operators are continuing to drill new wells in Appalachia and Haynesville, et cetera. So I think it's just going to take some time to really see production declines from associated gas.
Thanks, Russell. Scott, your thoughts?
I can't disagree with what Russell said. The only thing I would probably add to that is there's a lot of natural gas domestically in the U.S. and to turn on the drilling machine to introduce new supply into the system is I think fairly easy to do, and it'll be done by the lowest cost operators, both from a F&D as well as an LOE.
Thanks, Scott. Jay, what do you think?
I always worry about with the horizontal wells, the fracking technology we have today, that what the decline rates are going to be. It's a very, as we all know, a lot of these wells come off 60% from their flush production after the first year. That's a pretty fast treadmill. And so I think if you see a continued sort of pause in new drilling, reduction in associated gas that Russell and Scott mentioned, in combination with this decline rate for these long horizontal wells, you actually may see a recovery just because, as I say, the treadmill is run past people. I think the other wild card is going to be recovery in global LNG, and that's demand related.
Thanks, Jay. Tim Albino, agree, disagree, up or down?
I agree. I think that gas prices will ultimately go up. The question is timing and at what level are they going to reach that equilibrium for supply and demand. And I do believe a wild card here are the U.S. elections. If there's a change in administration and greater regulation, we could see a relatively significant increase in pricing over 21 to 22.
Thanks, Tim. All right, Chuck, bring it home. Are we all together?
Yeah, everything's been said, but it hasn't been said by everybody. So my ad would be that I think that the decisions whether to produce or shut in are really driven by the economic factors rather than the fact that they're in bankruptcy. So I'm not sure an uptick in bankruptcies is going to correlate to any change in pricing. It's really going to be the macro pricing environment and the business decisions they're making as to whether they can pull it out of the ground economically. And that's going to be the same if they're in distress and out of court or whether they're in court.
Thanks, Chuck. Okay, we are unfortunately out of time. We still have a number of questions to answer. We will answer you by email. Feel free to send in additional questions to anyone. Thank all the panelists for your time and for your expertise and your guidance. And I want to thank our audience, and we hope you enjoyed the webinar. Thank you, everyone.